case on this morning's docket. Case number 107159, State of Kansas v. Warren.
May it please the Court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Cedric Warren. May I please have 3 minutes for rebuttal?
3 minutes is granted.
Jury convicted Mr. Warren of one count of premeditated first-degree murder of Larry Ledoux, one count of intentional second-degree murder for Charles Chop Ford, and one count of attempted premeditated first-degree murder for Brandon Ford. As an initial matter, given the time, I intend to submit issues 5 through 9 on the brief, along with any other issues we don't reach this morning. With that, I'd like to move into the first issue relating to whether or not the district court erred in not granting a mistrial following Veneerman Williams' statements. Ordinarily, with the test for a mistrial, we look at whether there's some sort of fundamental failure. If there is, we move to the second step, which is whether or not the trial can continue without injustice, and then ordinarily harmless error follows. We contend, however, that in this particular situation, the error implicates the fundamental right to a trial, to a jury trial, thereby bringing structural error into play.
Let's review what happened. The defense counsels were allowing their clients to look at the questionnaires that had the personal information of the jurors, and one juror says, "That scares me that you're doing that," and then defense counsel says, "We want a mistrial because we got caught showing the information."
No, first of all,
He didn't say one. One juror says, "I'm scared," and then the defense counsel wants to use his own act as a basis for declaring a mistrial.
okay. First of all, the mistrial request wasn't until for a few pages of discussion about the matter, to my recollection. Second of all, there's absolutely nothing wrong, as far as I know, with a defendant participating in his voir dire, including reading these jury questionnaires. From reading the record, this is the procedure in Wyandotte County to expedite voir dire. We get this information about each panel member, so you can kind of get a jump on who you're going to strike, the questions you're going to ask, so you can cut down upon presumably extensive time spent questioning and repeating these things.
I understand
This
that
isn't
concept, but their home address doesn't have anything to do with that process, does it?
We didn't make the questionnaires. This is something the district court produced. I don't see how the defendant can be faulted for questionnaires he had nothing to do with creating.
Okay.
And I also like to point out, it's my understanding that the defendants, the only time they get to look at these questionnaires is when they're sitting there at voir dire. They don't get to take them back to their cells. They don't have any other opportunity to look at them. So it's not like the defendants could sit and copy just these matters. And in fact, I'm not even sure that the defense attorneys get to, because it seems to me, at least from the district court statements during his attempt to cure the situation with the jurors, that even the trial attorneys, it sounds like, don't get to take copies of these home. So it doesn't sound like to me this is a situation where somehow trial attorneys, they're certainly not told to do so, but that they could sit and somehow redact these things and give them to their defense. Either there's just no reason the defendant should have anything held against them in this situation.
Did the defense ask for any cautionary instruction from the court?
No, because they believed it was irreparably tainted.
And that juror was struck for cause. So your prejudice is that it tainted the evidence.
Yes, that's exactly.
And the judge ruled that no one else complained.
Yeah,
But the judge did not question it.
yeah, and that's in a nutshell. That's what we think should have happened. Perhaps had the judge made some sort of curative statement to the effect of these guys aren't dangerous, something to that effect. You don't have anything to be afraid of. That may have helped, but that's not what the admonishment was. Even though that was the admonishment in Blitch, was you don't have, in the federal case I cited, but really there's not a whole lot about this out there, where the federal judge said, we've been doing this, and in the history of the U.S., I don't know of any time when anyone has ever had a reason to fear for their safety about this, something to try and calm the jurors' fears. That didn't happen here. It just said, the district court just said, this is the way we do it, this is why we do it, and they're going to be destroyed afterwards.
Are you asking us to change the long-standing standard of review that we have for motions for mistrial?
No, I'm saying that this is a unique situation because this happened at the particular time that it did under these unique circumstances.
So
That this implicates structural error.
So no reasonable judge would have done what the district court did in this case. Is that the prong for our abuse of discretion standard?
I think it's not even. I think structural error takes it out of abuse of discretion.
Well, that's why I asked. I mean,
And I think this
abuse of
court's kind
discretion
of.
is our standard, so you're saying that we don't consider abuse of discretion in this case.
Sorry, I was confusing the test for the
This
two-part
motion
motion for a new trial test with the standard review. I'm
You've
sorry.
got a motion for mistrial.
Sure.
So you want us to not use abuse of discretion in analyzing this problem. You want us to say that if the error gets tainted, it can't be pulled back and it's structural error and you have to start over again.
Well, I think structural error falls into this court's recognized there's different categories of abuse of discretion. There is, of course, the long-standing, recognized, no reasonable person would take the same action. And we contend, first of all, that that's the situation here. Inherently also because of one of the other definitions of abuse of discretion is the judge doesn't follow the law. When you don't follow the law, it is an abuse of discretion. And we contend here that this was a situation because of structural error that not only would no reasonable person do it, but it is inherently as a matter of law a problem.
Do you have is there anything in the record to support the notion this was an exclamation by jurors that he feared of this information, and the theory is that fear was somehow then transferred to the remaining veneer people? Is that kind of the theory here?
That's exactly.
It's contaminated.
Exactly.
Start all over again because of that statement that.
We're not saying you have to start all over again.
Well,
Saying the appropriate thing in this situation
or some sort of curative
then to pull
action taken.
Well, to pull each juror in and say, hey, okay, this is the situation. This isn't something you need to worry about. Can you proceed and decide this case on the facts without any worry about this? On an individual. That's what the Blitch court says.
Is there anything in the record to indicate that there was some sort of contamination or this fear was spread throughout the jury pool?
It's a tough question because both of the defense attorneys pointed out that there was a visible reaction among the jurors. And this district court actually said, yeah, they reacted. But then a page later, the district court says, well, I disagree somewhat. No one came forward. No one nodded. The only reaction was while we were at the bench.
Remind me, was this juror struck for cause?
The juror was, yes.
I couldn't remember if it was struck for cause or for entry later.
The juror was struck for cause, and then they brought the whole situation back up at the conclusion of voir dire on a separate second motion for new trial.
And as I recall, there were several fairly open-ended questions asked of the jurors about whether they had anything else based on what they'd heard, that caused them concern, those kinds of things. Why isn't that sufficient? I mean, why does that inquiry have to be singular to this specific issue? If the jury heard the exclamation, saw this juror being struck for cause, which would inform them that if they had a concern, this was a way off the jury, if they truly had a fear, and yet none of them expressed concern when there were the open-ended questions.
That's exactly what happened in Glitch, and the court said, and I think it ties back, that's the reason I also cited the Yerk case, because just because a juror is silent on things, that doesn't necessarily mean that they're okay with it. In Yerk, the juror had read the newspaper article that had all the priors in it. And that's the Kansas case. And even though he had said, well, I'll probably be okay with this, the court said, no, there's evidence that he'd been tainted. Now, that's different here because we don't have, obviously, the actual individual inquiries. And I think that's where Blitch comes in, kind of to fill in the gaps of what the problem is. In Blitch, just like here, they dismissed the problem juror.
The defense didn't ask for individual court hire, did they?
They didn't.
And do they have the burden to do that? I mean, if you're gonna base your argument on structural error, it seems like perhaps you have a burden of showing actual taint, not just possible taint.
I think it was the fact of the matter is it's the district court's duty to ensure the impartial jury. This has been brought up, and the only curative action was this admonishment that didn't do anything particularly to tell the jurors that these weren't guys you need to worry about. And as the clock's running, I want to tie in the second issue to this too, because it's taken alone. I wouldn't have raised probably the second issue had in a vacuum. And frankly, was there an objection to the statements about the mob and all that? I would have raised that too, even though individually that might not have been enough. But these things all enhanced the problem that occurred with the first issue. They made these guys look like they were bad guys. And frankly, the fact that the state, for the life of me, I don't understand how the Bushmaster rifle that was found at the house on Lawn Street was introduced into evidence, because that's wholly irrelevant to this case. It was not involved at all. There was no way it could have been involved. The AK that they talk about at the other house was not the Bushmaster. The AK related to the 7.62 millimeter rounds that were found in the driveway. That's the type of round that goes in an AK-47. The Bushmaster is a .223 round, which may be something, I don't recall if that was in evidence, but there is no reason whatsoever that Bushmaster rifle should have been brought up, because it does not, it's not tied to the crime, it has nothing to do with it. But instead, that comes in and makes him look like he's a dangerous guy because he's tied to this assault rifle. All these things go together, make it look like Mr. Warren is a dangerous guy, and there are real reasons that jurors should be afraid, and there was nothing to assuage those fears. And we contend it's something that was underlying the trial. The state says, well, there was no prejudice from this. He got convicted as charged. That's the prejudice. It's kind of one of those, proving a negative type situations, absent any corrective type measures being taken. I'm out of time. I'm not sure. I really had hoped to talk about the motion for new trial issue, but given that I'm out of time.
I've got a question, Chief.
Sure.
A lot of your issues are founded on Brandon's inconsistent statements. Tell me what inconsistencies you think are relevant. I know he testified differently about the food they got at McDonald's, but when we're talking about what really was relevant on the relevant facts, what were the inconsistencies that you think would have made a difference?
We start off, Mr. Ford gets met by the officers at the scene. His first statement is, I got dropped off, and as I was walking up to the house, there was gunfire, so I ran off. Didn't see anything that says I wasn't armed, lies about that, lies about having been with them. Next changes his story. Well, I was there, but I was in the bathroom, didn't see a thing, didn't see who was there, didn't know anything. Now,
And
just
the-
on
and
those
the
two
third-
statements,
and
then
the
we start
third-
to evolve into
Excuse
what,
me, counsel, and then the third statement was he was on the couch.
well, that was at trial. No, the on the couch didn't come till at trial. That was when he went from being, first he was in the bathroom and he peed on the floor when he heard the gunshots. Then he went to the bathroom and came out and saw some people at some point. I can't remember if that was the next day or if that was a preliminary hearing. Then it evolved from, I caught a glimpse of him to, I was on the couch and saw everything the whole time.
And at trial, the defense attorneys were aware of those inconsistencies. Why wasn't that pennies from heaven for a defense attorney with the sole eyewitness for the state making those inconsistent statements? Why was that prejudicial? Why wasn't that fodder for impeachment?
In a vacuum, it would have been. And they did try and impeach him on it. But first of all, we have this overarching first issue problem where the jury is not, they're inherently afraid of these guys and want to get them. Then we have this in with the motion for new trial. I think one of the crucial things about the motion for new trial situation is the evidence that the state actually brought up during trial. The state was talking about potentially bringing in as motive this Broderick case, where supposedly an acquaintance of Mr. Warren's had been charged with the murder of Brandon Ford's brother. And the state says, well, that's a reason why they should have been, maybe they were watching their back type situation. Well, the converse is true, and that's exactly what was pointed out in these subsequent things that the letter, kind of letter/affidavit, and the affidavit, that there was actually, this was the reason why he wanted to implicate Mr. Warren in these things. He wanted him to pay for the other murder. He was actually, the true murderer had someone to do with Joe Freeman, which is another huge thing that changed on Brandon Ford's testimony. First, he says, once it evolved into, I saw this black Yukon outside, it was Joe Freeman he had this Yukon. And by the time you finally get to trial, it's, oh, Joe Freeman doesn't even have a black Yukon. He's got a gray Volkswagen and a white pickup truck. No, I'm good buddies with him. I'm not afraid of him at all. But his own brother, Joe Ford, says that's just not true, that he told me it was this Yukon and that it was, and that Joe Freeman had been threatening him and this and that. And according to these subsequent affidavits, Brandon Ford said, yeah, it was Joe Freeman, but Mr. Warren's also buddies with Mr. Freeman, and so he's going to pay for this other thing too. It's such a convoluted mess. Yes, in a vacuum, if you didn't have any of these things, and you had just the changing story, then we'd be in a whole different world, but we don't. This whole trial is just a mess. And for all these reasons, along with the ones I haven't had time to reach, we contend this court should reverse, and in the alternative, for the other reasons that were submitted in the brief, this case needs to be remanded for resentencing.
Any further questions? Thank you, counsel.
Please the court, Cheryl Lidkey, Chief Deputy District Attorney. We don't believe that the standard of review on the first issue should be structural error. Standard of review when a court denies a motion for mistrial has historically been abuse of discretion. And we believe that in this particular case, there was no abuse of discretion. When the veneerman expressed concern for his safety, the judge, we believe, reacted as most judges would and tried to stop that juror from commenting any further, tried to alleviate any other concerns that other jurors might possibly have.
How did the court do that? How did the court alleviate the concerns for the others?
Because the court instructed them, I call it an instruction, told the jury, informed them about how these questionnaires worked, what we do with that information. That
By
this is-
telling them that they didn't get to take them home, they have to memorize their home address at the table.
by telling them that this is how all of our criminal jury trials go, that questionnaires are routinely reviewed by counsel and used for the purpose of selecting who we think is best going to serve on this jury, and that there were other parts throughout the trial that I think also alleviated any concerns that other potential jurors might have had about what they're to do with this information. But when you're looking at this issue from an abuse of discretion standard, you have to ask yourself, would other judges, reasonable judges, agree with what Judge Burdens did in this case? You also have to ask, did the court make the correct legal conclusions, and is the court's finding supported by the evidence? And I think the answer to all three of those abuse of discretion questions is yes. In order to declare a mistrial, the court had to have concluded that there was prejudicial conduct that occurred, that a fundamental failure had occurred in the proceedings, and secondly, that it was impossible to proceed without injustice to either side. And I think the answer to both of those questions clearly was no for Judge Burns. There wasn't a fundamental failure in the proceedings at that point. We had one veneerman, not even a juror, this is just on the panel, this isn't a juror, who has expressed some safety concerns. It was obvious that he wanted to get off this jury. I think you can tell from his comments that he made and the quickness with which we released him for cause. We didn't want him to stick around any longer.
But that's a question I have. When he wasn't immediately struck for cause, was he? I mean,
It was fairly quick. It was not immediate, no.
But we had the question earlier whether the other veneer persons would have known that this person was struck for cause because of that fear. Would others have known that to be able to raise that?
I don't think so. If I recall correctly, the strikes for cause were done up at the bench. I don't believe that was done where the rest of the panel heard that.
Well, that surprised me, because usually when potential jurors learn of a way to get out, you have more than one raising the concern. So
Right.
in this case, the others did not know that they could get off the jury by expressing that same fear.
Well, it's hard for me to speculate
Well,
on
I
what their
know.
mindset was.
But they didn't obviously know.
I don't think it was obvious, no. I think it's important, too, to note that during this questioning and informing of this one potential juror, that nothing prejudicial about the defendants was revealed. And I think if you're assessing whether or not it made it impossible to proceed without injustice, or whether this was in fact prejudicial conduct, I think that's an important factor to consider. Nobody at any time said anything about these particular defendants, that it was worse in this case for them to have the questionnaires because of these particular defendants and something prejudicial about them. There wasn't any misconduct by the rest of the panel, which I think is one way this case is distinguished between the Yerk and Blitch cases. There wasn't, we didn't have the type of prejudice and misconduct that you have in those cases. I think it's also important to note that the jurors who were ultimately picked to serve on this jury were given further instructions throughout the trial and at the conclusion of the trial regarding the presumption of innocence, the state's burden of proof, that you have to base a verdict on evidence. You're not supposed to, you're supposed to disregard any testimony that is not admitted by the court, and that their only job is determining the guilt or innocence of the defendant.
And that's
We pre-
compelling. That's compelling to a juror that's afraid for their family's safety.
Well, we presume that jurors follow instructions, and all of these jurors were instructed to do so. And so the other significant thing in this case is that there is no evidence to suggest that any juror was concerned about their safety other than this one particular veneer man. None of them said so. The record is clear that none of them, nobody else expressed a concern about their safety. And the court specifically noted in the record that Judge Burns, noted that there was no other reaction to the comments by any of the other jurors. So to suggest that or speculate that there could have been other jurors that were concerned about their safety is just speculation. I think the evidence in the record would suggest otherwise. If you think that it was error, which I'm asking you to find that it was not, then our second argument is that it was harmless error, and that there was other compelling evidence in this case that led to the convictions. You had Brandon Ford, who was an eyewitness in this case, and albeit he had several inconsistent statements, and frankly, we didn't know how a jury was going to take him, but they did have a long opportunity to observe him on the stand. They saw him being zealously cross-examined by two attorneys about his inconsistent statements, and they chose to believe him, apparently. You had...
Was that cross-examination, or did that cross-examination include his jailhouse statements that he was getting even?
No, but those were available before trial, and that's argued in my brief under the newly discovered evidence issue. Apparently, according to these other defendants, who were some of them also charged with their own murders, we don't really know because they didn't show up at the motion for new trial.
And those statements were actually sent to defense counsel, or did it come through your office, or how?
They did not come through our office. They were apparently sent to the defense attorneys. I objected to the affidavits coming in, but the court let them in anyway. But they were just supposed affidavits written by these other inmates. But the answer to your question is no. Brandon wasn't cross-examined about his supposed recantation, but could have been, because that evidence was certainly available to them before trial.
But the court let the jailhouse affidavits come into evidence.
He did at the motion for new trial, not at the jury trial.
Okay, all right.
The defendant argued here today that the lower court should have polled the jurors individually to explain to them that there was no need for concern, and to direct them that they had to base verdicts on evidence and not comments of the veneer panel. And I would suggest to the court that that's pretty much what the judge did, except he did it to the panel as a whole rather than individually. And I'm not seeing a difference in terms of harm to the defendant. And the remedy he's asking for is pretty much what Judge Burns did anyway. Aside from Brandon Ford's eyewitness testimony, there was physical evidence at the scene that corroborated Brandon Ford. There was DNA evidence that corroborated him. There was ballistic evidence that corroborated his version. There was motive that had been established, that this was basically gangs feuding over money and dope. There had been prior dealings in that household with money and dope. And one of the murder weapons was found in a vent in an apartment where we found that both of the defendants immediately after this murder. So the evidence is compelling, and so if you believe that a mistrial should have been declared, the fact that Judge Burns did not declare that mistrial was harmless. The second issue regarding refusal to declare a mistrial when Detective Block referred to the defendant and his associates. Again, this is an abuse of discretion standard. We would ask that you find that other judges, reasonable judges, would agree with the lower court, that the lower court made the correct legal conclusions and his findings are supported by the evidence. There was no prejudicial conduct that made it impossible to proceed with injustice. This is especially true when you look at everything that the defendants did not object to in the evidence regarding the defendant and his associates. For instance, the evidence established without objection that these murders were committed for $20,000 and a large amount of cocaine that was hidden in a dryer downstairs. The evidence established without objection that there were multiple guns and assault rifles that were used and stolen during the incident. The evidence was that there had been prior drug transactions at this house involving the defendant, and there was no objection to that evidence. There was also evidence that he was a member of a local gang, and there was no objection to that evidence. So to say that Detective Block's one comment about knowing the defendant and his associates was prejudicial, I think is unrealistic. To further argue about the newly discovered evidence issue, number 3, again, we're looking at an abuse of discretion standard. We're asking that you find the lower court did not abuse its discretion in denying this motion. First of all, it wasn't newly discovered evidence. As I pointed out in my brief, according to these affidavits that were presented to the trial court, this evidence was available prior to the trial. Brandon Ford could have been cross-examined about them. And secondly, the evidence wasn't so material that it probably would have caused a different verdict in this case. You should be suspicious about the reliability of the so-called new evidence that was presented at the motion for new trial. Case law supports our theory that these affidavits should be viewed very suspiciously. They all had bias against the state. They were all being prosecuted for their own crimes, including murder. They continued the sentencing for 10 months after the trial to try to get their evidence together for this motion, which is another reason that I find it awfully suspicious that even after 10 months, none of them could be produced for actual testimony at the hearing. And if there was in fact a recantation by Brandon Ford, we believe that it was easily explained. He was scared. This young man threw up during his testimony at the preliminary hearing. At the trial, it was very apparent that he was afraid to testify. And so it's not a far stretch of the imagination to understand why, when he's in a cell with some of the defendant's buddies and he's getting ready to testify against their buddy, that he might recant something to their face. The fourth issue was the severance issue. Our argument here is that, again, this is an abuse of discretion standard. The lower court properly denied the motion to sever. There were no antagonistic defenses in this case. Both of these defendants said, we didn't do it. We weren't there, we didn't do it. They might have had some conflicting evidence, but it wasn't mutually exclusive defenses. It wasn't something where there was a brutal problem where one of them was going to testify and the other one couldn't cross-examine him. They did not shift the blame to each other. And even if they did, that by itself wouldn't have created the antagonistic defenses. I want to touch briefly on, well, I see I'm out of time.
Do we have any questions of counsel? Thank you, counsel.
Thank you.
I think we've already done that. Unless there's additional questions about issue 1, I wanted to talk a little more about issue 3 because the state took some time on that. First of all, just a couple of factual questions that are in that the state's argument brought up to me is I don't see where there's any evidence that these guys that wrote these affidavits were buddies with Mr. Warren or Mr. Moore. There's absolutely no evidence of that. And while truly they were admittedly charged with crimes, And perhaps that may be some bias against the state. There's no evidence that these guys weren't equally biased for some other reason against Mr. Warren and Mr. Moore. And I think that perhaps this dovetails into that Bullock case, the unpublished case I cited in my brief, where really there's a problem when you look at just the cold record without testimony. There's no way really to evaluate the credibility based upon just these affidavits. The district court had no reason to disbelieve these statements.
And the use of that was simply to impeach Brandon Ford's testimony.
I think it's more than just impeachment. It's kind of like the Norton case, where it's not just a matter of impeachment. Typically, when this court,
What was the purpose then?
it's pointing out that he perjured himself, and that there is other evidence that it corroborates these other theories that go along with the fact that it was someone else that was there, and Joe Freeman, perhaps, as the alternate murderer. Because and specifically, I think it's Marshall's affidavit, and I may be confusing it, or Marshall's letter / affidavit, or maybe McInnes's, where they got into more detail. That Holmes's affidavit wasn't as expansive, but where they specifically said Joe Freeman was the murderer, and I'm just doing this because Mr. Warren's one of his boys, or however he phrased it.
What evidence had come in about Freeman? Anything?
That he was afraid of him, that he'd been by there earlier to buy drugs, and I believe that he'd been in and out of jail, and that he had he had said, "I'm going to kill you." I think Joe Ford was the one that testified that Mr. Freeman had told Mr. Ford, "I'm going to kill you and your brothers." And that seems to me to point that Mr. Freeman might have been the actual murderer. With regard to whether it was truly newly discovered, the state even said, we don't interview everyone at the jail, and I don't know how somehow Mr. Warren and Mr. Moore were supposed to psychically know that these witnesses were out there. While these comments from Mr. Ford to the others may have occurred before trial, there's no way they know. And this is kind of another extraneous fact, I suppose. Wyandotte County is one of those counties that farms out its inmates. They don't all sit in the Wyandotte County Jail. They go to somewhere in Missouri. And it's a real possibility that they weren't even in Wyandotte County. But the bottom line, I think, and the fact also the state says they didn't show up for the hearing. These guys, obviously, they're in jail. They don't get the choice of whether they're going to walk down and come down to court. And I think Mr. Zimmerman even expressed, and I think there was a continuance even, because he tried to subpoena these guys and get them transported, and they never were transported over there. So I'm not sure how, given the fact that they weren't the affiants or letter writers, were not in control of where they could be at what time, how that the defendants could be blamed when they weren't the reason they weren't there. But what I want to emphasize from Bullock is, the Bullock court remanded for further proceedings to have an evidentiary hearing, and perhaps that may be the more appropriate situation here, as I believe it was Mr. Allen, Mr. Warren's attorney below, or Mr. Bullock, I don't recall, there's a bunch of different attorneys, but the point is the attorney at that hearing said, "Judge, we should probably go ahead and just bifurcate this because it sounds like there's a factual problem, and I'd move that we have an evidentiary hearing on this." And perhaps that would have been appropriate, but there was no basis whatsoever for the district court to just out of hand make a credibility determination in this situation when all he had was the cold record. I mean, this court doesn't, that's kind of the reason this court doesn't reweigh credibility, is it's cold record. You don't have the witnesses in front of you. So perhaps that's the appropriate remedy with respect to the motion for new trial, is to go back and have further proceedings for an evidentiary hearing.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time, the court